Mike Papantonio on the line with us, the attorney and host of Ring of Fire Radio, now ringofireradio.com, the website, and now also Ring of Fire TV, Sundays at noon Eastern Time on Free Speech TV. And Pap, welcome back to the program.
Tom, how are you, my friend?
I am great, but I'll get better. I hope the same is true of you.
Good, yeah.
Indeed. Okay, so my question, isn't it time for Anthony Scalia to put down the black robe and just start wearing his white hood to court?
Well, you know, the unfortunate thing is what we've done is we've made some of these, we've taken the Supreme Court and we've created this myth around the Supreme Court. When I was in law school, as a matter of fact, you know, semester after semester, I'd have a constitutional law professor talking to me about the idea that Supreme Court decisions are not based on politics or ideology. They're based on stare decisis. They're based on precedent. They're based on prior cases that they review and then follow a rule of law. Nothing is clearer or should be clear to the American public that that's a lie. That simply is not true. And this five-member majority of the very conservative majority of the Supreme Court has proven that to be very true. Listen, this is a judge. Now, can you imagine? I've never, look, I read everything that comes out of there because I have to. It's how I make a living. But can you imagine a Supreme Court judge saying that we have to do away with the Voter Act because all it does is perpetuates entitlements for the races? I mean, you know, and if you really consider how outrageous that is, you then start understanding this man is not a jurist. He's a politico. He's a hack. He's a political hack, always has been his entire career, but he's a political hack with a robe on. So we look at him and we say, oh, we have to hold him up in some kind of greater honor. It's a shame that we haven't seen that earlier.
Well, at least FDR was willing to call the Supreme Court out on their politics. And you know, eventually when he threatened to use Article 3, Section 2 to change the composition of the court to say any justice over 70 years old, all of them in aggregate end up with one vote, and they're called Justice Emeritus, and then we get to add new members to make up for those that are missing, which was called packing the court. And frankly, I just read a book on this about a year ago, from a historian, you know, that was written in the 60s, 50s, and 60s, who had lived through the time and been part of the process, and he was of the opinion that had FDR actually pushed that, he probably could have won that case. But what happened was the court in 37 just started changing their decisions and going along with them, even though the composition of the court hadn't changed. Tell me that's not political?
Well, of course, and he was going to change the numbers, increase the numbers.
Yeah.
They saw what was coming. But FDR had the courage to do that, Tom.
Yeah.
And, you know, the unfortunate thing here with Obama, he's a constitutional law professor. And as a constitutional law professor, he's kidding himself. I don't know if you caught this, but it was an outrage. I still am scratching my head saying, really? But a couple of weeks ago, he's in front of a crowd, Obama is, and he says, you know what, it's okay if they do away with the Voters' Rights Act because we're going to be able to solve the problem. You're still going to be able to vote. Well, I didn't hear the end of that sentence because there is no solution, Tom. If you take Section 5 out of that act and the Department of Justice has no teeth, understand, think of the irony of this. Alabama is up arguing this right now. 240 times they've had to have the Voter Rights Act come, Section 5, they've had to enforce that against Alabama for Alabama's intent to purge voters, come up with ID scams that were completely bogus, to redistrict, you name it, Alabama's tried everything. Right. 240 times, Section 5 has saved that state, saved the people in that state and given them the right to vote. And here we have a president that says, you know, we're going to be okay even if we don't have that. It's
well, this is the logic that is being argued before the Supreme Court, right, is that Section 2 gives you know, people who live in Alabama standing to sue if they feel like they've been discriminated against. But if Section 5 says that the state has to pre-clear any changes in law. So if only Section 2 survives, then all the Republicans have to do when they want to suppress the black vote or the Latino vote or any other vote, in particular, young people, old people, you name it, they've figured out a way to suppress it selectively. All they have to do is put that into law about a month before the election, and there will not be time to litigate that case. The election's held, they get the result they want, and then whether they win or lose, if they lose and the law gets wiped out, that's fine with them. They just wait until a month before the next election and introduce the law all over again.
Tom, you know what's so ugly about this is we're out there, and you have this is the best example I can give you of the fact that this isn't naivety. These judges know this majority, this conservative majority, Kennedy, Scalia, Alito, Roberts, Thomas, they know exactly what they're doing, and for them to even have to even suggest to us and dress up like they're trying to find some real logical, rational reason for doing away with it is absurd. They know that in 2006, the 20 days of hearing, thousands of documents were reviewed by Congress and the Senate unanimously voted to say, we have to have this. Right. As a matter of fact, you had Sessions and you had Shelby, not exactly two great bastions of liberal thinking in Alabama, who voted to say we need to extend this Voter Rights Act.
Right, 2006.
2006, excuse me. And so the point being, this is all a facade, and until we can be honest enough with ourselves to where we can say, look, we know who they are. The media, the traditional media, trying to understand by way of some involved political analysis is laughable. Mm-hmm. And so it comes down to sheer politics. You have a Scalia that making statement after statement, and you do wonder, where's his white sheet? Yeah. And of course you've got his handmaiden, Clarence Thomas, sitting there, who's never asked an intelligent question since he's taken to the court.
Yeah. And whose wife is, at least for many years, was, living off the Heritage Foundation. I don't know if you and I have ever discussed this, Pap. I'm actually working on a book on judicial review. Nowhere in the Constitution does it say that the Supreme Court has the right to strike down laws passed by Congress. Thomas Jefferson went insane when Marbury versus Madison was decided in 1803. He said, by this decision, the Constitution has become a thing of wax to be molded in the hands of the judiciary. The only two times, the court is the final court of appeals. It's pretty explicit in Article 3. And literally from the founding of this republic up until roughly the Civil War, for the first 80 years of the existence of the court, only twice did they decide on the constitutionality of anything. The first time was in 1803 in Marbury, and that created such a firestorm. I almost used an obscenity there. Such a firestorm that they didn't do it again until 1856 in Dred Scott, and that worked out really well. Yeah. And it's like, I don't, but they did. Literally the court was like deciding whose dog killed whose chicken. They were literally the court of last appeals. They were an appeals court, the final appeals court. And now all they do is decide constitutionality, and I'm of the opinion that what this has done is it has turned America from a constitutionally limited representative democratic republic into a constitutional monarchy, and the monarchs are these 9 people in black robes of the Supreme Court.
For life. Look, that was an excellent point, and it's just right on point with anybody that's analyzing this problem. But if you really think about it, the only issue that this court should be talking about is this act constitutional? It's already been held constitutional. It's already been written in so many different ways. It's on so many different levels. It's all, the Congress has stated, they've renewed it time after time. The only question is it constitutional? Now, the arguments have been proposed, of course, and throughout the years in one form or fashion, is that it lacks equal protection, it lacks due process, but that's been tested and it's been decided.
Yeah, and the 15th Amendment says, second sentence, Congress shall have the power to pass legislation to enact this. Like, how could it? And that's part of the Constitution. Mike Papantonio, ringofireradio.com. Check it out. Pap, great having you with us as always.
Thank you, Tom.